My concern is also the amount of women, the number of women that are continuously in and out of the house. There was up to 3 women staying nights. It was like a revolving door. And
Mr. Hockman did not appear for the scheduled motion hearing. And so the court had asked for a Schultz to have him before the court today. At the time of the initial hearing, with the order that entered on March 10th, 2025, the court had ordered with regard to the minor child E that she shall attend school every day that school is in session unless excused due to illness, as evidenced by a doctor's note. And on an interim basis, neither party was to leave the minor child alone without a responsible adult being present. The matter was otherwise preserved.
Both parties, please raise your right hands.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. I'll begin with Mr. Hockman. Sir, please state your name for the record.
Tony Hockman.
Mr. Hockman, there was a previous hearing scheduled in this matter, and it was scheduled for March 7th. Did you appear?
No, sir.
Why not, sir?
I forgot about it.
Okay. And as a result, we didn't have the hearing, but the court did hear some information from mother. And as a result, on that day, the court entered an interim order regarding, and it's what Ms. Schultz stated, that the minor child may attend, as the child attends school. If the child is missing from school, there has to be a doctor's slip. And the court also ordered that neither party can leave the child alone without a responsible adult present.
I didn't get that one.
Pardon me?
I got the letter.
The order?
Mhm.
Okay. So other than forgetting to appear, it's alleged that you left the child alone.
Not after I got that letter. She's been staying with the grandparents.
But regardless of when you received, oh, okay, so you're saying that after,
Yes, because I was told by CPS that they questioned her and they see no reason why she couldn't be there home alone.
well, that's not the court order. We consider the court orders only.
And I got the letter and that's when I got a hold of my parents. And she's been staying there on my roof now.
Mom, your response.
on the 17th of this month started his week. And I had gone to his house to check on her, like I have been previously since he's been on second shift, because she has been alone and he knew that I was going to check on her. And at 7 o'clock at night, she was there by herself. So I took her with me back to my house. Well, actually, I apologize. I took her with me to get her lunch for her field trip the next day. And then I took her back to my home and made dinner. To which then he at 8:42 had messaged saying that he was home. So I brought her back. The next day we had her field trip and we didn't get home from her field trip until 4:45. Nobody was at the house, so I kept her with me. She thought that he was going to be staying after. I apologize. So I had messaged him at 6:48, telling him that if he was going to be working late, that she could just stay the night so that she didn't have to be woken up to be brought back for school the next morning. To which he replied that he wasn't working over. And so I took her back to his house at 10:15 and I stayed until he got home so that she was not alone. And then I apologize. Oh, I'm so sorry. On the 19th, I had then went to check on her again, and she was alone. So I took her back.
Sunday at the time?
Yes. So I took her back to my house, we make dinner. And again, before he returned home from work, we went back to his house and I remained in my vehicle again until he returned home. Once he returned home, I left because he was there and she was no longer alone. And then starting that next Thursday, or that Thursday, following that day is when he left her with his parents. So Thursday and Friday, and if he worked the weekend, she was with his parents as well that weekend.
So you're alleging the last day the child was left alone was March 19th?
Yes.
Okay. The order that was entered in this case dated March 10. When do you recall you receiving it? Did you receive it the very same day? Or was it sent to you in the mail
It was mailed the 11th and I received it on the 13th.
on the 13th? How do you respond to that, sir?
I mean, I don't have a problem with her going there and picking Emily up on my weeks. She's got dinner there every day. There's food in the house. And I see no reason why she can't be there while I'm at work. I mean, I am working, supporting the house. There's no issues. And Emily told me her mom fears that someone's gonna just walk in the house and kidnap her. That's not gonna happen. There's never been no problem since I've been on second shift.
When did you begin second shift, sir?
Might have been close to December, and it wasn't by choice.
Oh, I understand. What's the current status regarding legal physical regarding court?
An order entered on January 24th of 2019, granting joint legal and joint physical custody. And then the most recent order regarding custodial time entered on July 13th of 2022. And the parties are granted equal custodial time on a week-to-week basis. Exchanges occur on Mondays during the school year, and they're also granted alternate holidays for the friends of work.
Okay, thank you. All right. Well, we'll address first the motion to show cause for failing to appear in this matter. I'll accept Father's comments that he forgot about it. Unfortunately, Mother was here, and obviously it's a waste of her time. And as a result, the court's going to order a $100 fine. That'll have to be paid by. Can you get it in by April 11th?
I think it's today.
Today? Okay. Payable to the friend of the court. And we address that matter. Now we are talking about allegations of a violation of the order that Mr. Hockman wasn't here on. But let's begin with the motion regarding custody and or parenting time. Ms. Gage, what is the proper cause for change in circumstance you believe that the court should be looking at relative to changing custody or parenting?
Prior to the order, he had been being pulled from school to babysit or not sent to school in order to babysit. She had also been allowed to just skip school. She is, prior to this last order, she was being left alone all night until he would return home from work, usually about 11:15, unless he worked over. I was told specifically that I am not allowed to lock the door when I would leave her, after I would ensure that she was safe. I was specifically told I'm not allowed to lock his door, because if she's not up, he can't get in. So I fear for her safety because she's a minor child who has no phone. She previously had a phone, but was not responsible enough with it, so is no longer allowed to have it.
She's 11, correct?
Yes.
Go ahead.
what Mr. Hockman does in his personal life is for him. But my concern is also the amount of women, the number of women that are continuously in and out of the house. At some point, or at one point last year, at the end of last year, there was up to 3 women staying nights. And then it was like a revolving door. And the effect that that is having on her worries me, plus the safety issue of that. I apologize. I have, Mr. Hawkins does have food in his home. He will not cook on his stove. So unless there is something that she can microwave, she will not eat. So that was my concern there. And I have taken food to his house so that she had something to eat, as well as when our daughter had previously been living there before she moved again. I have even gone to food pantries just to make sure that there was, because I don't have way extra to supply 2 houses. So I would sometimes go to the food pantry and drop stuff off to him. I am worried that her schooling was being affected because of being pulled out of school.
What are you alleging the amount of days a child may have missed?
She did not go November 27th. December 2nd, she did not go. January 9th, she was not in school. On the 8th, she was pulled from school early.
January 8th?
Yes, I apologize.
It's okay.
On January 24th, she was kept home from school as punishment because the prior night, when he returned from work, she was not home. He had messaged me asking if I had her. I said no. We got in contact with her friend who I had seen previously in the day with. We contacted her father to see if he had the girls there. He did not. I had asked Mr. Hawkins to go look for her, go to the Parker school to look for her. He said he would not go look for her. So me and my husband had gotten ready to go to town to go look when he had said that she had shown up. On January 27th, she did not go to school because Mr. Hawkins had been gone all weekend. And he was left with one of his ex-girlfriends. That ex-girlfriend had gone to work that Monday and left her children with E. So she was there watching those children. And then I believe that was all of them.
And that's the primary reason for your motion to change custody, correct?
Yes,
And are you talking physical custody?
and legal. But mainly physical, because I worry about her safety when she is there.
Okay.
Because she is alone, or had prior to the last order been alone all the time.
Scott, what's your response, please?
I've never punished her and kept her home from school for grounding. Schools have sent her home growing up. And I think the prior times of her missing school, I might have still been on first. Because there were days that she just wouldn't go to school. She'd play out sick or I was too tired. But since I've been on second shift, I'm up in the morning getting her up ready for school.
What about November 27th, December 2nd, January 9th, January 27th?
I could have still went on first. I would have to go back to see when I was switched on second. I've only been on second for, I think, 2.5 months.
Okay. But those were during your time, so correct?
Could have been.
You had
I
the
don't-
child. Mom, is that your allegation?
Yes.
Okay.
And when I do make her go to school, when she said she was actually sent home last week on my week because she was throwing up at school. I
Did
still made her
you get
go.
a doctor's notice?
They sent her home, so I didn't even think they did the doctors for it.
All right. Court finds that there is a change in circumstance since the entry of the last order. The parties have joint legal, joint physical custody. The court had heard a motion barely when father was not here regarding the absences from school, and that's the reason for the change in circumstance. As a result, the court is going to order a friend of the court investigation relative to custody and parenting time. In the interim, though, the court is going to keep the prior orders in effect. We're still week on, week off. However, the prior orders that the court entered on March 10 absolutely apply in this matter, which means that in the interim, the child is to attend school every day that school is in session unless excused due to illness as evidenced by a doctor's note. We have to have a doctor's note. Either parent, if it's your time, child's not in school, we need a doctor's slip. If not, the child needs to be in school. And on an interim basis, the court is continuing the previous order that neither party shall leave the minor child alone without a responsible adult being present. According to Mr. Hockman, since he was made aware of the order, the child's been with, sounds like his parents on those times. So that is going to continue. Relative to the allegations that father left the child alone after the court order, clearly the court order was entered. And it appeared the child was left alone. Father wasn't here for the hearing. The notice of the order being sent, I should say service, indicates that that was mailed out March 11, 2025. At this point in time, it's not to happen again while this matter is pending. Neither party can leave that child alone without a responsible adult there, period. So I'll pass on the alleged violation clearly, but it can't happen again while this matter is pending. Do you understand that, sir?
Sure.
Okay. Just do you understand?
Yes.
Ms. Schultz.
As to the friend of the court investigation, is the court ordering both legal and physical?
At this point, according to the motion, it's physical, not legal. So we're staying with physical. Go ahead.
May I make one request?
What's that?
That as long as she is left with a responsible person who is not on the sex offender registry or has had any charges of child endangerment or anything,
Abuse or neglect?
yes,
Any objection to that, sir?
No, sir.
okay.
Only makes sense. What? That'll be in the interim order as well. Do you have any questions?
I got one thing to say. So,
Is that a question?
well, the one thing I got upset about her locking my doors is there was no communication. So when I come home at 11 o'clock, I'd be locked out of my house. I'd have to bang on my daughter's window, wake her up, just so I could get in my house.
You don't have a key? Get in.
I got a key, but when she's home, you know, I leave my keys for her in case she wants to go uptown. If she locks the door, if the door gets locked, keys are there. But
Keys
no.
are very expensive.
Yeah, I know, sir, but
I mean,
I'm just saying,
it's not
like-
that difficult to go to one of the local stores here and just get an extra key made.
Oh.
I mean, it's just common sense.
but communication goes a long way too. And
Well,
she
and
could've
that
said-
leads me to another point, because I was reading the messages going back and forth. It doesn't look like that's accurate. It looks like text messages, unless.
No, we haven't gone through Accuses in probably quite a few years.
I believe the applicant was previously ordered, Your Honor, but Neither party has brought it to the front of the court as an issue.
Okay,
No, we've gotten along for quite a few years. She's just upset that I'm on second shift and Emily's home alone. But I've never left her overnight. I lied to my ex just so I could keep my little ones longer, saying that I was,
well, be careful what you say in the courtroom, sir. I mean, the exes could be listening. All I can tell you, if you're being able to communicate, I'm not going to change it. Just communicate with each other. That's all. If there are any issues, share them with each other. And if we have to go back that close, we will, but it sounds like you're communicating. That'll be all. Thank you.